Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. On June 23, 2026, the Supreme Court handed down its decision in Exxon Mobil Corporation versus Corporación Cimex S.A., the Cuban government-owned company that for decades operated Exxon's stolen oil refinery and gas stations in Cuba. 6 justices sided with Exxon. Justice Kavanaugh authored the majority opinion. Justice Kagan led the dissent, joined by Justices Sotomayor and Jackson.
The bottom line, the Helms-Burton Act, a 1996 law Congress designed to punish the Cuban government for seizing American property, itself strips Cuban government-owned companies of their normal legal shield from U.S. lawsuits. Exxon no longer needs to satisfy the separate requirements of a different immunity law just to get its billion-dollar case in front of a judge.
And for any American family or company that lost property to Cuba's communist government after Fidel Castro seized power, this ruling swings the courthouse door wide open.
Before we go further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. As you may recall from our preview episode, this case traces back over 60 years to 1959, when Fidel Castro seized power in Cuba.
And Castro telegraphed his intentions almost immediately.
A year into power, Castro publicly declared that his communist government would confiscate all Yankee property in Cuba. He followed through. The Cuban government swept through American businesses across the island. Exxon Mobil, then called Standard Oil, maintained an active Cuban presence, an oil refinery, terminals, packaging plants, and more than 100 service stations.
Gone overnight.
Gone. Cuba transferred Exxon's entire operation to 2 Cuban government-owned companies, Union Cuba Petroleo, known as CUPET, and Corporación Cimex. Those companies operated and profited from Exxon's stolen assets for over 60 years. Not a dollar went back to Exxon.
And Exxon had no real legal path to sue them.
Not at first. Foreign government entities enjoy what lawyers call sovereign immunity, basically a legal shield that blocks you from dragging a foreign government or its companies into court unless Congress specifically opens that door. So Exxon sat on its claim. In 1969, the U.S. Foreign Claims Settlement Commission, a federal body that evaluates Americans' confiscation losses, certified the value of Exxon's stolen assets at more than $70 million. With decades of prejudgment interest and the treble damage multiplier available under the law at the center of this case, that figure today exceeds $1 billion.
$1 billion, sitting in Cuban government hands. And then the story shifted.
In early 1996, Cuba shot down 2 unarmed private planes over international airspace, killing 3 American citizens. The incident generated enormous outrage, and Congress responded. President Clinton signed the Cuban Liberty and Democratic Solidarity Act, commonly called the Helms-Burton Act, after its sponsors, Senator Jesse Helms and Representative Dan Burton.
Helms-Burton finally gave Exxon a legal weapon. The act created a private right of action, a legal tool that lets a private citizen or company go to court for any American national whose property Cuba had confiscated. That right of action ran against anyone who traffics in the stolen property. And here's the key language. The act defined person who could get sued to include any agency or instrumentality of a foreign state. Congress drafted those words specifically to reach Cuban government companies like CUPET and Cimex.
But the law sat frozen for more than 2 decades.
From 1996 through May 2019, 23 years, every president from both parties exercised the act's built-in suspension authority. Clinton, Bush, Obama, and Trump all concluded that permitting the cases to move forward conflicted with U.S. foreign policy at the time.
Until the Trump administration changed course. On May 2, 2019, Secretary of State Mike Pompeo announced that détente with the regime failed, and that holding Cuba accountable for seizing American assets now drove U.S. policy. That same day, Exxon filed suit in the U.S. District Court for the District of Columbia against CUPET, Cimex, and later Cimex's Panamanian alter ego, seeking more than $1 billion in damages.
And then the Cuban companies immediately raised a second shield. Right, they pointed to a separate federal law, the Foreign Sovereign Immunities Act, or FSIA, enacted in 1976, which grants foreign governments and their companies a baseline legal shield from U.S. lawsuits. Under the FSIA, a court may only hear a suit against a foreign government entity if the plaintiff satisfies one of several specific enumerated exceptions. The Cuban companies argued Exxon satisfied none of those exceptions.
The district court sided with the Cuban defendants in 2021 and dismissed the case. A divided D.C. Circuit panel affirmed, concluding Helms-Burton harmoniously coexists with the FSIA, meaning Exxon needed to satisfy both laws. But Judge Raymond Randolph dissented sharply, concluding Helms-Burton established a specific, independent, and exclusive cause of action. That alone stripped the Cuban defendants of immunity.
The Supreme Court granted cert in 2025 and heard argument on February 23, 2026.
So, what exactly did the court set out to answer?
Two federal laws sit in tension. Helms-Burton creates a right to sue Cuban government-owned companies for trafficking in stolen property. The FSIA creates a default immunity rule for foreign government entities, with specific exceptions that allow suit. The question: does Helms-Burton itself strip that immunity, or does Exxon also need to clear the FSIA's separate exceptions?
Two locks on the same courthouse door.
Exactly that. And here's the practical trap, one that Exxon's attorney, Morgan Ratner, pressed at oral argument right out of the gate. Helms-Burton simultaneously created the right to sue Cuban government companies and codified a massive economic embargo prohibiting most commercial dealings between Americans and Cubans. But the FSIA exceptions require proof of commercial activity or direct commercial effects inside the United States. The embargo made that nearly impossible to demonstrate.
So the FSIA exceptions and the embargo together create an impossible loop. Deputy Solicitor General Curtis Gannon, arguing for the United States as a friend of the court supporting Exxon, called it a gross mismatch at oral argument. Cuban government entities functioned as the main culprits trafficking in confiscated property, he told the justices.
Stacking FSIA requirements that depend on commercial connections between the U.S. and Cuba in a law that simultaneously bars those commercial connections produces nonsense.
Did the Cuban companies have a counter to that?
Their attorney, Jules Lobel, argued that the embargo never cut off all trade. He pointed to roughly $8 billion in U.S. exports to Cuba under general licenses, millions of travelers, and about 50 Cuban importers receiving American agricultural goods. Justice Sotomayor pressed Gannon directly at argument. Could a plaintiff ever clear both gates, Helms-Burton plus the FSIA? Gannon acknowledged some narrow cases might work, but conceded that in the vast majority of suits against Cuban government entities, the dual requirement probably would prove impossible.
So how did 6 justices reach reversal?
4 interlocking steps. Kavanaugh starts from a 2024 precedent, Department of Agriculture, Rural Development, Rural Housing Service versus Kurtz, which stands for the principle that when Congress creates a cause of action and expressly applies it against government agencies and instrumentalities, Congress thereby strips those entities of sovereign immunity, even without a separate, explicit waiver provision.
And Helms-Burton checks both boxes.
2 checkmarks. Section 6082 A(1)(a) creates the private right of action. Section 6023(11) defines person to include any agency or instrumentality of a foreign state.
Kavanaugh noted that only a handful of statutes in the entire U.S. Code create a cause of action expressly aimed at foreign government entities. That rarity itself signals something extraordinary, and Congress intended it that way.
But what about the FSIA? Doesn't it automatically control any suit against a foreign government company?
That's where the second step lands. And this may be the majority's most powerful punch. Kavanaugh invokes a 2023 case, Financial Oversight and Management Board for Puerto Rico versus Centro de Periodismo Investigativo. Let's just call it FOMB, which holds that Congress does not authorize a suit against a sovereign with one hand, only to bar it with the other. At oral argument, Gannon called the FSIA plus embargo combination a Swiss cheese situation, a cause of action riddled with holes so large the whole remedy collapses.
The majority agreed. Kavanaugh pointed to multiple Helms-Burton provisions that presuppose actual lawsuits and enforceable judgments against Cuban entities, provisions addressing filed actions, final judgments, and settled claims against the Cuban government. That language makes no sense if the FSIA prevents virtually every such case from leaving the starting blocks.
The third step involves a key jurisdictional provision, Section 6082 C, 1 of Helms-Burton directs that suits under the Act proceed like any other action brought under Section 1331. The General Federal Question Statute, FSIA suits run through Section 1330, a different provision that conditions jurisdiction on satisfying an FSIA exception.
At oral argument, Justice Sotomayor challenged the government's reading here, pointing out that the section carries the label procedural requirements, not jurisdictional. Gannon's counter, the word other in the provision can only carry meaning if Congress treated Helms-Burton suits as a type of Section 1331 action, meaning they don't fall under Section 1330, meaning the FSIA's immunity gates don't apply. The majority added that the very next subsection of Helms-Burton selectively borrows one specific FSIA rule, service of process procedures for foreign entities. If the entire FSIA already applied, Congress would not have needed to cherry-pick that one provision.
And the fourth step brings in presidential gatekeeping. Helms-Burton grants the president plenary, meaning total, authority to suspend suits under the Act whenever national security or a Cuban democratic transition demands it. 23 years of continuous suspension proved exactly how seriously presidents took that power.
At oral argument, Justice Kavanaugh pressed Ratner directly on this point. He observed it would prove quite extraordinary for Congress to allow billions of dollars worth of claims to rest on a presidential on/off switch, constrained only by a national interest determination. Ratner flipped the argument, precisely because the potential wave of claims against Cuban government entities would prove so substantial. Congress built 4 separate suspension provisions into the statute as a diplomatic backstop. You don't need that kind of architecture, she told the justices, just to address a handful of edge cases trickling through embargo exceptions.
And Kavanaugh used that structure as the majority's fourth pillar.
The Helms-Burton Act's presidential gatekeeping mirrors how foreign sovereign immunity worked before the FSIA arrived in 1976.
Back then, the State Department, operating under executive discretion, made immunity calls case by case. The FSIA shifted that responsibility to courts.
Kavanaugh found it incoherent for Congress to simultaneously reinstate executive gatekeeping over Cuban government suits, echoing the pre-FSIA world, and also require those same suits to clear the FSIA's court-driven immunity exceptions.
Stacking those two incompatible regimes produces a result that, as the majority put it, would make little sense.
So, what did the court actually do?
Reverse the D.C. Circuit 6-3, Justice Kavanaugh writing for Roberts, Thomas, Alito, Gorsuch, and Barrett. The Helms-Burton Act, read through all its interlocking provisions, abrogates the foreign sovereign immunity of Cuban agencies and instrumentalities. Exxon need not separately satisfy an FSIA exception.
The case returns to the lower courts to proceed on the merits.
And Justice Kagan's dissent? How sharp did it cut?
Very sharp. Kagan opened with what she identified as the most telling fact in the entire case. The Helms-Burton Act says not one word about sovereign immunity. That silence in her reading tells the whole story.
The majority would say Congress doesn't need magic words.
Kagan accepted that. She agreed Congress need not use magic words to abrogate immunity, but she pressed a deeper analytical distinction. A cause of action and an abrogation of immunity remain, in the court's own precedents, analytically distinct inquiries. Congress can create one without doing the other. Helms-Burton's definition of person, including foreign instrumentalities, defines who a plaintiff can sue. It says nothing about whether those entities retain immunity from the suit. Those stay 2 separate questions, and Helms-Burton, she argued, only answered the first one.
And Kagan pointed to something Congress actually did, and something Congress deliberately did not do.
2 key moves. First, Helms-Burton did amend the FSIA, but only its execution immunity provisions. Execution immunity protects a foreign government's property from seizure to satisfy a judgment. Congress changed that rule in one specific, narrow way for diplomatic property, but Congress left the FSIA's jurisdictional immunity provision, the rule about whether a plaintiff can file suit at all, completely untouched. When Congress amends one provision and leaves another alone, courts presume the choice reflected intent. Second, the original Helms-Burton bill expressly added a new FSIA exception for confiscation claims.
The Department of Justice objected. The amendment would represent a sweeping extension of U.S. court jurisdiction inconsistent with international practice. Congress dropped the FSIA amendment from the final bill. Kagan's conclusion,
Congress looked at this directly, heard the objection, and chose not to abrogate jurisdictional immunity.
and her point about the cause of action still having real work to do,
Helms-Burton's cause of action runs against any person, including private companies and individuals, who traffics in confiscated property. Private traffickers stood as the law's primary targets. Congress designed Helms-Burton to deter foreign investors from partnering with Cuba to profit off stolen American property. That cause of action achieves its core purpose against private defendants. No immunity abrogation needed. The case the court heard that same morning, Havana Docks Corporation versus Royal Caribbean Cruises, proved exactly that. Private cruise lines. No sovereign immunity question.
time for what this actually means. So, what actually changes after this decision?
For American companies and families with certified claims against Cuba, the courthouse door just opened. Before this ruling, a plaintiff suing Cuban government entities under Helms-Burton ran directly into the FSIA wall. The Cuban government companies argued the embargo made satisfying those FSIA commercial activity exceptions nearly impossible. The Supreme Court eliminated that wall entirely.
Exxon's case specifically. What happens now?
Back to the district court to proceed on the merits. Exxon seeks more than $1 billion, reflecting the $70 million certified claim from 1969, plus decades of prejudgment interest and the statute's treble damage multiplier.
Cuba and Cimex now face that demand in federal court without the immunity escape hatch.
And for other claimants,
Dozens of pending Helms-Burton suits against Cuban government entities. Cases involving hotels, airports, ports, telecommunications infrastructure. Now clear the immunity threshold and move to the merits. Any American company or family whose Cuban property losses the Foreign Claims Settlement Commission certified now holds a live legal tool.
But here's the wrinkle Kagan flagged in her dissent, and Justice Alito raised at oral argument. Even if Exxon obtains a judgment against Cuba or Cimex, a separate FSIA rule, execution immunity, still shields Cuban government property from seizure to satisfy a judgment. At oral argument, Alito pressed Gannon directly. If Cimex carries no attachable assets in the United States, what difference does winning even make? Gannon's answer: a judgment carries strategic value beyond its immediate face. It creates leverage. It may convert into enforceable collection if U.S.-Cuba relations shift or future legal changes open new avenues. The majority footnoted that same point.
And the court punted one enormous question. The third country question. Justice Barrett pressed Exxon's counsel at oral argument. Does the ruling extend beyond Cuban government entities to foreign instrumentalities of other countries, say a French or Canadian company trafficking in confiscated Cuban property?
Ratner acknowledged her position probably sweeps that broadly. Barrett flagged that question as lurking in the background of the whole abrogation inquiry. The majority expressly reserved it. That question returns in future cases.
The court opened the door for Exxon and left the map unfinished for the cases that follow.
Either way, Exxon gets its day in court. So do a lot of other people who waited decades for one.
Decades. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast.
Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Think of us as the Helms-Burton Act of legal podcasts, creating a cause of action against your boring commute and stripping immunity from your Monday morning dread.
That may qualify as the worst Supreme Court analogy either of us has ever made.
And yet entirely airtight.
Definitely not airtight. Talk to you soon.